Welcome to Gosfield and Shay on Health Law.
Hey everyone, welcome into an all-new episode of Gosfield and Shay on Health Law with Alice Gosfield. I am your host, Mike Leon. Alice here is a nationally recognized healthcare attorney who has spent her entire legal career advising physicians on Medicare, fraud and abuse, Stark law, and value-based payment. She's known for her strategic clarity, prolific writing, and deep influence on federal healthcare policy. Today's episode, we're going to be talking about voluntary repayments. How voluntary are they, and how to do them correctly? Alice, it's good to see you as always. I don't know anything about voluntary repayments, so you're going to have to explain all of this here. But let me ask you here at this high level, because my understanding is the standard for repayment is knew or should have known, right? So for the physician groups out there, how much proactive auditing is legally required to kind of meet that reasonable diligence standard without creating, some type of unsustainable administrative burden?
Well, Mike, it's good to be here again. Thank you for having me. The government believes that ongoing internal auditing is essential to maintain compliance. They've said it in their model compliance guidance for physician practices, which is now 20 years old. And then in 2024, they issued new general compliance guidance as an addendum to all the various stakeholders who are expected to have compliance programs. They also suggest the use of risk assessments in that document, which means that they expect that people who get federal money will be paying attention to whether the monies that they are receiving are legitimate. With respect to voluntary repayments, the government has also stated amazingly that a single denied payment is a reason for the practice to look further and see whether they've had the same problem with that practitioner, with other practitioners, or otherwise. So the auditing process should be appropriate for the size of the entity, the extent of the billings. As an example, a pediatric practice doesn't send very many claims to Medicare, so they don't have to have the same scope of a program. But the point is to detect and identify problems before the government or a whistleblower finds them and repay them voluntarily.
Alice, let me ask you, how has the definition of identification of an overpayment, how has that changed in the rules?
So in the first iteration of the voluntary repayment rules, the idea of identified meant analyzed and quantified. In the amended version of the rules, which somewhat restricted the timeframes that are relevant and also expanded the scope of what the investigation has to look at, because you have to repay related repayments all in one fell swoop. So you can't nitpick your way through problems. You're supposed to do an analysis that finds anything that's related to what the problem is that you think that you need to repay. And the rules generally allow 6 months from beginning to end of the process, which is a little different from what it was initially. And once the payment is identified, which has to happen within that 6 months, you have 60 days to repay it.
Alice, speaking on that front, like in your experience, what are some of the most common mistakes that entities are making or have made when they're calculating that total repayment account after doing this internal audit and finding these billing errors?
Well, the statute of limitations for false claims is 6 years. So assuming that the practitioner who was involved in the problem has been with the practice for 6 years, you have to go back and look at each year. But you can't simply take the number of issues that occurred in the base year that you're using and assume that it arose with the same frequency in the prior 5 years. In addition, the conversion factor, which is the dollar amount that gets multiplied by the relative value units that determines what does Medicare pay for that, changes from year to year. So the amount that you would be quantifying from 1 year to the second year to the third year to the fourth year would all be different based on the conversion factor. And then there's the issue of when did the problem begin? In other words, you might have somebody, I had one client who had a practitioner who was going through a very bad divorce and suddenly started documenting very poorly. He had been fine previous to that. So they didn't have to go back 6 years because his problem had only happened within the previous 2 years. But you're obligated to do some kind of an analysis of how to do the extrapolation. Lawyers can be helpful with that.
Yeah. Well, I'm sorry to hear about that client with the divorce, but let me ask you about, I know the law says to pay the secretary, but these Medicare administrative contractors, they use sometimes their own inconsistent forms. So in that vein, what is kind of the safest way to physically return the money to ensure that it is properly credited and it is properly documented?
Functionally, there is no way to pay the secretary. The MACs get their authority that's delegated from the secretary, and there are only 13 MACs anymore. They have on their websites, all of them, a form to fill out for a voluntary refund, but most of them are oriented around a single claim or 4 claims or something like that. If you've got a problem that you're extrapolating over time, you want to repay it using that form, but having a description of how you analyzed the problem, what the method was that you used. It doesn't have to be statistically valid, but it has to be replicable. You have to be able to describe it. And again, a lawyer can be helpful in characterizing what it is that you are repaying and why the number is what you think the number should be. In some instances, the check actually goes to a different address than the form does, even though the form accompanies the check to the place where the check goes.
Well, again, all of this stuff, there's a reason why you're the subject matter expert on it, right? To explain to folks. Let me ask you, I'm thinking out loud now about like some of these entities like labs, these healthcare entities, vendors who provide services in response to physician orders. I'm sure they're obligated to repay monies received, right? They're obligated to repay monies received as a result of like some type of coding error on the physician's end.
They are, and it's actually worse than that. They get the ability to perform the service that they do based on a physician's order or a physician's prescription. As an example, if the services were not medically necessary, they get dinged for that in the same, even though the physician was the one who ordered the service. So in the model compliance guidance for laboratories, the OIG called out this problem in particular and said, they were focused on ways to prevent problems, which included things like requisition design. Does it push the physician to actually justify the medical necessity? Notifying physicians of the liability that they both have if these are not medically necessary services, physician acknowledgement of medical necessity, and then use of advanced beneficiary notices, which is where the vendor can say to the beneficiary, particularly if they've had experience with this doctor, we think this is not going to get paid for lack of medical necessity. You agree that if it's not paid, you're going to pay for it. But you can't charge the patient unless they've signed an advanced beneficiary notice, because if you're a participating lab, you have to take assignment.
Alice, let me ask you, at what point does a simple overpayment, how does it convert into a false claim? And piggybacking on that, what are some of the specific penalties per claim that providers, or including the physicians that we mentioned, what should they be most worried about?
So a claim is just an overpayment until you should have known that it's an overpayment, at which point this inherent obligation to be paying attention and auditing and figuring out whether the payments that you're getting are accurate. If the assessment, the analysis, the quantification has not occurred with regard to payments you weren't entitled to at the end of the 180 days, which is the entire period from the identification, the notice that you have internally that something was wrong, doesn't get repaid, then the claim becomes eligible for whistleblowers and the government for enforcement, and the penalties are enormous. It's more than $14,000 or more than $28,000 per claim, plus triple the charges that are on the claim. So the government's cash register is ringing long and loud on these problems.
Sounds like a lot of zeros that are going to be
Yeah.
attributed to that, Alice. So, Alice, as we kind of land the plane on this episode, I know that you've written about quality fraud. So let me ask you, if a hospital were to receive these value-based payments, but they fail to kind of meet the clinical quality metrics, is that technically an overpayment that must be voluntarily returned?
It is. And interestingly, some of the value-based payment models, the quality-based payment models, including MIPS, which is a physician program, requires self-reporting by the provider. So if you report that you did something that you in fact did not do and you got paid additional money on the basis of your false report, yes, that is an overpayment.
Hmm. Alice, it's great stuff. I appreciate the analysis, the insights, and explaining this all to the audience. Thanks as always.
Thank you, Mike.
And thank you to everyone out there for listening to this installment of Gosfield and Shay on health law. For guidance on Medicare reimbursement, fraud avoidance, all the stuff that Alice talked about, you need the help. You need Alice's help. Visit gosfield.com right now to connect with Alice and the team. And do me one more favor before you go. Hit like, hit subscribe, leave a review and comment, or share the episode with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.